morning, gentlemen. This case comes to the court from the Circuit Court for Unicoi County, Tennessee.
Need to introduce yourself first.
May it please the court, I'm Lowe Schultz Davis, and I represent Karen Lowe in this appeal. I'm a member of the Unicoi County and Washington County Bar Associations, and I began my career here in Knoxville more than 40 years ago with the law firm of Jenkins & Jenkins. I would like to reserve 3 minutes of my time for rebuttal.
All right, you may proceed.
Whether we look to ancient philosophy, such as Aristotle, society is stable only when we are all equal under the law. Or, as a more modern president said, no one is above the law and no one is below it, Theodore Roosevelt. The principle is consistent throughout time. The law should apply equally and fairly to all. The rules should not change in the middle of the contest. This case should be reversed for failure to equally apply the law to the parties and for alteration of the ground rules for the case the parties mutually laid down. The learned trial court heard and accepted many stipulations of the parties. The court questioned the stipulations and accepted them with multiple expressions of assent. Okay, fair enough, yes. Defendant husband stipulated that wife should have the divorce for his fault. Then, in her opinion, without explanation, the court taxed the wife, the prevailing party, with the court costs. This requires reversal. Of course, that's not the reason we're here, but it's an example of how the court treated the party stipulations. Through counsel, many stipulations were taken concerning property. Each party would retain their inherited property acquired during the marriage, and neither would make any claim against that of the other. The court quoted this stipulation, questioned it, wrote it down, and said, fair enough. 3 weeks later, and without explanation, the court changed the very words of the statements of the parties to, as to possession only. The parties in counsel had said nothing about possession only. Moreover, the parties had emphasized neither would make any claim to the inherited assets of the other. This record is devoid of those words until the court wrote its opinion. Under the great weight of precedent, beginning with Gibson's suit in Chancery, Sir Goinsville v. Sandage, a 1993 Court of Appeals case, Phelan v. Phelan, a 1964 Court of Appeals case, and Shea v. Harper, 2000 Supreme Court case, an open court concession by attorneys constitutes a binding stipulation that the courts will not disturb. That's the town of Sir Goinsville case. In construing stipulations, the court will give them the force and effect contemplated by the parties. That's from Gibson's suits in Chancery. It's very clear from this record what the parties contemplated. For whatever reason, the court interjected the doctrine of transmutation. That is, of course, a well-known concept in the law division of property. However, neither party pled that, neither party argued it. The court simply interjected it. Then, this principle of the facts supposedly underlying the finding were not equally applied. The court cited acquisition of wife's inherited property during the marriage as a basis to say it was marital property by transmutation, even though inherited. This principle was not applied by the court to husband's much more valuable inherited property, even though his was likewise acquired during the marriage. When we look at the factors under the case law that could result in such a result, the only one differing in regard to the wife's property was that the parties had lived in the home that she had inherited some 3 to 4 years before. However, a corollary consideration with regard to the husband's property, which consisted of a home in his name alone and adjoining land acreage, which is altogether worth more than $1 million. By his own testimony, he indicated that he had used all of the proceeds of the rent of that property to pay marital obligations. The differing treatment of the parties' assets here is a gross and almost complete unequal application of the law. Having found $170,000 of marital equity in property inherited, contrary to the parties' stipulations, the court appeared to ignore testimony as well as those stipulations in order to balance the values of the property in her ruling. Husband was ordered to get a vehicle he purchased post-separation and in which he invested $40,000 of marital funds, and then ordered that his remaining balance of some $43,000 was to be paid one half from proceeds of a piece of marital property from wife's interest, one half from husband's interest. Wife's vehicle, a much less expensive Jeep she had faithfully paid for on her limited income, would be sold, and the proceeds she was to receive would be given to the husband. There's nothing equitable about any of that, except the unjust attempt to balance the assets, having moved $170,000 from the parties' stipulations to marital assets and leaving husband's property outside of the balancing. Further, wife is ordered to borrow against her home $68,000, and all of that equity was inherited or purchased from her siblings with inherited funds. There's nothing equal about the application of the law there. TCA 364121C, subsections 5A, requires that husband dissipation of the assets be considered. He let a valuable trike motorcycle be repossessed. There is a deficiency judgment owed of $9,700. By his testimony, he broke 9 flat-screen TVs within a year. If we assume a minimal value for those of $200 each, that's $1,800 that he dissipated. And then, of course, there's the $40,000 he invested in the Jeep Gladiator, which by his action is in danger of repossession. One of the most puzzling things about all of this is that his income is more than twice that of wife's. The total of those dissipated assets is $51,500. The court's ruling again as to debt treats the parties differently. The lake property is to be sold and pay husband's credit cards, and that lake property was also stated to include a floating house that the wife owned before the marriage. There's an obligation on both parties' parts to take their equity from this lake property and wife's pre-owned property to pay husband's credit card debts and that deficiency judgment he owes. Wife is to pay husband one half of the value of all furnishings, even though he charged them, and also appliances for the Jonesboro rental house, which was awarded to him. These rulings require reversal or a new trial. There was a matter of annuities, and the trial court expressed much displeasure that the wife had forgotten to list an annuity that she had not accessed, husband had invested, she hadn't even thought about. Husband had proposed in his distribution of assets that wife should have that annuity. He claimed not to remember that or to understand it. But the court ordered wife to pay him one half of the value of the difference in their annuities. Husband's separate debt was in excess of $131,000, and it was ordered to be paid one half by wife from the share of the lake proceeds. At the same time, the $500 plus a little bit that the husband owed wife for slashing her tires was not to be paid from his share of the sold property. That's a significant financial benefit to husband to go from owing $131,000 to owing only about $2,000, including the $500 he owes wife. Whereas wife will go under Judge Cook's order from owing $16,000 to $133,000, these financial outcomes were not considered by the parties and require reversal. The final point I want to make before closing my initial argument is that wife requested continuation of her order of protection, which husband had violated by slashing her tires. The court said no, inexplicably, saying only that the fault of the husband would not be considered in that regard.
Let me ask you, it appears that we're missing a Rule 7 table, which is normally required if we're going to make some adjustments to the division of property and make any determination about debt. You realize you didn't file a Rule 7
I
table?
included in the argument a table that related to this misapplication of debts and quoted the numbers that the court had missed in miscalculating those items. If the court desires a chart that's more detailed, I can certainly supply that.
So you didn't file a Rule 7 table?
I did not.
Okay.
Anything further?
Thank you.
May it please the court, my name is C.J. Roberts. I'm here on behalf of the appellee, Robert Lowe. Speaking as to the stipulations, there were a number of stipulations that were brought up at the beginning of trial. And as Ms. Schultz-Davis noted, a stipulation is typically taken as it is given to the court, and attorneys can be bound certainly, or clients can be bound certainly by what their attorneys stipulate to. However, we cited a number of cases where it's not always just a matter of what's said. It has to be clear, it has to be specific.
What's unclear in this case about the stipulation?
Well, I think the unclearness comes about when you look at how the attorneys questioned the clients while they were on the stand, how Mr. Lowe responded about the house and the money that was spent.
Tell me what's unclear about the announcement to the trial court regarding the stipulation, not what occurred later in the trial.
Sure. The unclearness is it just that you're getting possession of the home?
Was there any statement about possession when that stipulation was made to the trial court? Was the word possession used at all?
It was not. The word possession was not used.
So how would the trial court later conclude that it only mentioned possession?
I think that came about through testimony and with the attorneys asking questions about it, in the sense that if this were known to everyone that Mr. Lowe was not going to pursue a claim in it, then why were the attorneys asking questions about what amount of money he put into the home or what his what he believed his interest to be. And then Mr. Lowe himself became very agitated on the stand when he was talking about what all debts he had incurred on the credit cards and what he had, that he had put that money into the home and the work into the home.
But he knew that at the time that the stipulation was made at the beginning of the trial, didn't he?
I do not think that Mr. Lowe did know that.
Well,
that is
what
the
would have
type of
occurred between the time that the statement was made at the beginning of the trial and later during the trial where he uncovered something that he didn't know earlier?
Sure. The type of language that was used there, and I believe the exact language was free of any claim or something to that effect when the stipulation was announced. And that I can't say that that's the case everywhere. I'm not sure if that's geographical, but I took that to mean that. I took that to mean that he was not pursuing an interest. Meaning that
counsel, you took that he was not pursuing an interest in the Grant property.
I did.
That was understood at the outset.
That's what I understood.
And that was mutually agreed to.
I do not think that Mr. Lowe understood it that way. And I think that's why a stipulation has to be very specific, to the point that the cases that I cited mention even asking the parties questions about the stipulation under oath, making sure that they're clear, making sure that they understand, and that was not done.
Obviously, that's a better practice to, once the parties, or if the parties are going to testify, to make sure they understand what the stipulations are. Was there anything unclear about your understanding of the stipulations when the announcement was made to the court?
The short answer, no. There was no misunderstanding on my part.
Okay, now, I'm going to let you explain something in a minute. Does what the court did in this situation reflect what your understanding of the stipulation was when it was announced to the court?
No.
Okay. One more question.
Sure,
and
sure.
I'm going to let you say whatever you want to do. Was the court ever asked to correct that perceived error?
By us?
Either of the parties?
By either party, no.
Okay, and I misspoke. I've got one more question. Was the court ever asked to make any of these determinations that it subsequently made based upon these stipulations that both counsel seemed to understand when they were made to the court?
If I recall correctly, I do not believe that we did closing arguments. It's our local rule that we list the property, list who it's determined, who's supposed to have it, if it was acquired during the marriage, after, or anything of that regard. And we also do proposed findings, or basically what the client is desiring in the outcome. And I will say that in our Rule 9, we had specifically asked for interest in that house.
Rule 9, the local Rule 9, the local filing consistent with the local rules?
Correct.
Okay.
We had asked for that, and
Was that consistent with the stipulations?
that was not.
Was that subsequent to the trial?
That was prior to the trial that we filed the
Rule 9?
So
And then the stipulation, and then you made the stipulation subsequent to that?
Yes, just immediately before the trial started. I'm sorry. Did I answer?
I kept asking you questions. You were going to say something, so I told you I'd give you that opportunity.
I think this flows nicely in the sense that the courts have said when determining if something is specific, if stipulation is specific, that the court can consider the circumstances under which the stipulations were made, and the trial judge is best situated to see that. And it's not part of the record, and it's not...
Then we don't need to get into it if it's not part of the record.
I'm just demonstrating in the sense that, I've mentioned this in my brief, that morning I had not even had this case on my calendar, and I was about 2 hours late getting there. Everything was rushed, harried. There was no other cases on the docket. We were meeting immediately, just seeing if there was anything that that we could come up with. And the trial court was aware of that. The trial court sees these things. So under the circumstances, I do not believe that my client understood what was happening, and that definitely became evident after the fact.
But in the stipulation, it wasn't just your client giving up any interest he may have in the Grant property. The appellant was also giving up any interest in any claim that she may have in the Main Street property. So this stipulation worked to the advantage of both parties, didn't it?
Certainly, it worked to the advantage of Mr. Lowe. However, I don't think that we had any question in our mind that his was separate property. It was inherited, and there had never been anything put into it by the wife. It's been said.
There was proof that the wife supposedly made improvements to the Main Street property, wasn't there?
I believe the proof was that she had painted. I believe that was the most that there was that was said, and the parties.
The Grant Lane property was also inherited property, wasn't it?
I'm sorry?
The Grant Lane property.
The Grant Lane property was not inherited. The wife had inherited a sum of money. I take that back. She inherited a portion, but she bought out her siblings.
Using her separate property?
Yes, there was no testimony put on whether that money was kept separate or how it came about.
Well, did it need to be, since you had a stipulation?
And I understand that. However, there was proof put on about the amount of work time, money that went into the remodel and increasing of value to Grant Lane.
If you had these stipulations in the beginning, why did the parties feel the need to get into putting on proof about the stipulations?
And that's where it started to become noticeable that that was not necessarily the understanding, because when Mr. Lowe was questioned right from the beginning, the testimony got into Grant Lane and about several of the things that we had stipulated to, quite frankly.
Did you ask those questions?
I did not until I was on redirect. The plaintiff had asked those questions, and when Mr. Lowe answered a lot of those questions, it got to the point that trial judge was saying, so what you're trying to tell me is that you've got a claim to this. I believe that's more or less what she had stated. You're saying that you have a claim to this house, or that you've put money into this house, and Mr. Lowe stated exactly. As to Ms. Lois Schultz had pointed out different treatment of the parties. The trial court delineated and did a graph and showed what each side was receiving, and it came to be fairly equal, though Mr. Lowe still did not quite receive the benefit that the wife did. The decisions that were made would appear to have been made because it was the equitable decision to make, trying to put the parties as in a good of spot as the court could possibly put them into. There was a lot of debts, but nothing was suggested as to dissipation. Dissipation wasn't argued. There was no proof that it was marital funds that were being used or that was used for the vehicle that he purchased. In fact, he had testified that Each party had received insurance money. Each party had received money from a house that was sold. That was never brought up, never questioned whether.
Was that because the stipulations took care of everything?
It did not. It did not take care of things in that regard, I do not believe. The truck was mentioned that it would be the property of Mr. Lowe and that he would be responsible. But as to where the funds came from to pay for it or anything of that nature, no stipulations mentioned that. That's something that has purely been brought up after the fact.
You said the truck, there was a stipulation as to the truck that would be his truck, and he would pay for it. But then the judge ordered the balance to be paid from marital assets. Is that right?
That is correct. The truck itself and the debt associated with that, the understanding was that Mr. Lowe would maintain that since, he had gone out and done that after the parties had separated. But there were other things that came up that we were unaware of at trial, such as, and I see my time's about up. May I finish answering your question? There were things that were brought up at trial that we did not know, like the annuity, for example. And the way that things had shifted and with the new information being brought forward, I think the court had to maneuver things and change things to suit the needs of the parties and to.
But Mr. Lowe had an annuity of almost an equal amount as Mrs. Lowe, but then he withdrew his funds from the annuity?
The funds had been withdrawn. I don't know that we established when the funds were withdrawn, but it would have been, I believe the wife testified that it was after he left Texas Instruments, immediately after. It was early 2000s, 2002, 2003. And then, of course, the documents that were submitted that showed that he still had a bit of money in the annuity, those were quite old. And I put a footnote in the brief that we had since even found that he did not still have that. That had been long since withdrawn as well. So thank you for listening to my argument today, and we would ask that you leave things as the trial court found that they should be.
Thank you.
Gentlemen, the stipulations were very clear, as is recited in my brief, quoting the transcript. Wife will keep Grant Lane and Irwin as her separate property, free and clear of any claim of husband. Husband will keep 1159 East Main Street as his property, separate and free and clear of any interest and claim of wife. That was a recital of the court of the stipulation after it had been made. That's found.
Why did you put on proof about perhaps the wife making a claim against the Main Street property? Given that you entered into the stipulation, what was the necessity for that?
Proof as to the Main Street property. I cross-examined when there was discussion by Mr. Lowe, basically unsolicited, of what he had put into the properties. And he wanted to say over and over that he used the rental property, the rental income from the property at Main Street to pay for everything, and take the position that the wife did not pay anything. There were stipulated documents which showed that wife had paid utilities, taxes, various obligations. The camper, which Mr. Lowe was awarded, and he had allowed to go into default. And the court interjected some questions saying, you, Mr. Lowe, are not seeking to have anything from the Grant Lane property. And he responded, no, but I want the court to understand. The court, in other words, what you're trying to tell me is that she spent marital money. She spent marital money to improve the Irwin property that she is keeping. And he replied, exactly. And then the colloquy went on to discuss if we add in that Wells Fargo account, it was just an account he thought of at the trial, there's some $51,000 you're saying is owed on credit cards. Are you asking the court to divide that debt? And that was the reason for Mr. Lowe's often unsolicited statements about what he had paid and what he had owed. He had this huge credit card debt. Again, he went from owing $131,000 under the court's ruling to owing about $2,000, and $500 of that to wife. Wife went to owing $133,000, which includes money she's got to pay to husband, because $170,000, contrary to the statements, was shifted to a marital asset with no corresponding shifting from Mr. Lowe's inherited property. We'd ask the court to reverse the trial court and either to adjust these equities or to direct that there be a new trial. Thank you, gentlemen.
Thank you. Thank you, counsel. We appreciate your briefs, your oral arguments. We'll take this matter